In today's lesson, we will learn more about a promisee's right to suspend performance before a promisor's breach by examining the case of AMF versus McDonald's Corporation. We'll take the opportunity to better understand sections 2609 and 2610 of the Uniform Commercial Code, which concerns parties' right to adequate assurance of performance and cases of anticipatory repudiation. First, let's review the two relevant sections of the UCC. 2609 states that if a promisee has reasonable grounds for insecurity, in other words, if it has reasonable doubts that the other party will perform her promise, the promisee can demand adequate assurance of performance. This request must be made in writing. The promisee, if commercially reasonable, may suspend her own performance until she receives adequate assurance. And if the promisor doesn't give adequate assurance within a reasonable time, not to exceed 30 days, it's considered a repudiation of the contract, and the promisee can cancel. UCC Section 2610 governs what happens for a repudiation of the contract. When one party repudiates the contract, the aggrieved party can await performance for a reasonable amount of time or resort to any remedy for breach. Regardless of which option the aggrieved party chooses, it can suspend its own performance. Keep these two provisions in mind as we explore this case. So here are the facts of AMF versus McDonald's. McDonald's, the defendant, appellee in this case, paid AMF, the plaintiff appellant, some $20,000 for a prototype computerized cash register. McDonald's installed the cash register in its Elk Grove store. 4 months later, McDonald's ordered 16 more such registers. 5 months later, McDonald's franchisees ordered 7 more. The first register was to be delivered in February 1969, with the others delivered during the first half of that year. In February 1969, the registers never arrived, and AMF moved the deliveries back to July 1969. On top of this, the first test unit didn't test satisfactorily. At this point, McDonald's was starting to get concerned. At a March 18, 1969 meeting between AMF and McDonald's, McDonald's requested that production of the registers be stopped until the parties negotiated performance and reliability standards for the machines. The parties were unable to agree on the standards. In April 1969, the AMF prototype was removed from the Elks Grove McDonald's for poor performance. On July 29, 1969, McDonald's canceled. AMF then sued for wrongful cancellation. McDonald's sued AMF to recover the purchase price of $20,385. The cases were tried together. The trial court held for the defendant in both cases. AMF then appealed, and the instant court affirmed. The question is, did McDonald's rightfully terminate the contract pursuant to UCC sections 2609 and 2610? The court held that yes, McDonald's was right to terminate the contract, but it took several steps to get there. Let's go through the court's rationale by looking at each step of the analysis. Let's start with UCC section 2609. The court found that McDonald's clearly had reasonable grounds for insecurity, entitling it to demand adequate assurance of performance under 2609. In other words, McDonald's had reason to believe AMF wasn't going to perform. What conduct should constitute reasonable grounds for insecurity? This is a bit of an open-ended question, but in addition to the failure to deliver on an individual installment, a merchant's insolvency or even rumors of bankruptcy might be sufficient. But what about the UCC section 2609's requirement of a written demand? You'll recall that McDonald's never issued a written demand for assurance of performance. For this, the court excuses McDonald's from the requirement of a written demand by noting that the UCC is to be liberally construed and declaring that McDonald's request for further negotiation led to a, quote, clear understanding that McDonald's had suspended performance until it should receive adequate assurance of due performance from AMF, unquote. McDonald's is clearly sophisticated enough to read the UCC, so why does the court have the power to waive the UCC's writing requirement? By what right does this activist judge contravene legislative supremacy? This decision is not a conventional application of UCC's 2609 explicit requirement that the demand be in writing. Moreover, there was nothing in the opinion that indicates there was even a formal oral demand. Instead, the court applied 2609 to the parties' routine negotiation behavior and gave it legal consequence. 2609 is already a section that is replete with fuzzy standards. When are grounds for insecurity reasonable? What is an assurance that is adequate? When is suspending performance commercially reasonable? When is failure to provide adequate assurance not within a reasonable time? The requirement of a demand in writing was one of the few rule-like requirements, and this case dared to fuzz up this element as well. On the other hand, a realist might claim that this is a victory of substance over form, especially where the lack of form was not prejudicial. The court then concluded that AMF never provided the assurance that had been demanded, and this failure amounted to a repudiation under 2609 subparagraph 4. Thus, McDonald's rightfully canceled pursuant to 2610 subparagraph B. AMF's behavior in this case was clear. It never gave assurance it was going to perform. But what kind of conduct should constitute adequate assurance? Mere words might at times be adequate, but in other cases, adequate assurance might also require additional forms of consideration from the promisor, such as a bond or a letter of credit. Many contractors would be surprised to learn that by promising they were taking on an obligation to provide adequate assurance if reasonable insecurity arises, much less that the adequate assurance might include taking substantive action to assure the promisee of your ability to perform. What was the last step of the court's analysis? The answer is UCC section 2711, subparagraph 1. That section lays out the buyer's remedies when the seller repudiates the contract, which includes canceling the contract. Demanding adequate assurance can be a risky strategy. A promisee's right to demand adequate assurance at first seems to importantly enhance the promisee's defensive right to assure the promisor's performance. After all, 2609 allows promisees to suspend their own performance even before a promisor breaches or repudiates the contract, and allows a promisee to force the promisor into anticipatorily repudiating their promises if they can't give an adequate assurance. But the right to demand adequate assurance carries considerable risk. The promisee who wants to suspend their own performance under UCC section 2609 must have reasonable grounds for insecurity, and they must make a demand in writing demanding adequate assurance, and they must show that they have not received adequate assurance from the promisor. If a promisor suspends performance and a court subsequently finds that one of these requirements was not present, the promisee's attempted defensive action will constitute a breach of contract by the promisee herself. What starts off as a legitimate concern about whether the other side will perform can ultimately become a finding that the promisee herself breached by mistakenly exercising her 2609 defensive rights. In other words, suspending performance or treating a contract as repudiated for failure to give adequate assurance might backfire on the promisee making the demand. Maybe the fuzzy-like standards of 2609 are a feature and not a bug of this section. The possibility that either side might end up being held liable after a promisee invokes the section might help drive both parties to negotiate a compromise, and it dampens the likelihood that promisees would overuse the 2609 option. The right to demand adequate assurance also exists in common law. Remember that the UCC only applies to a sale of goods, so we care about the common law rule for service contracts and non-good contracting. Section 251 of the Second Restatement purports to state the common law rule on adequate assurance, though it is not followed by all the states. For instance, New York has not embraced the adequate assurance doctrine outside of the UCC's Article 2, but sometimes will apply it to non-UCC cases. For instance, in one New York case about an electricity contract, a court was asked whether a party has the right to demand adequate assurance of future performance in a contract not governed by the UCC. That New York court answered the question in the affirmative by extending UCC 2609 to the contract by analogy, concluding that the sale of electricity was sufficiently similar to a sale of goods, and that parties to a long-term commercial contract, which is complex and not reasonably susceptible of all securities features being anticipated, bargained for, and incorporated into the original contract. As a law student at Yale, I used Section 251 in a lawsuit against Yale itself. During a disruptive 10-week strike in the fall semester, I helped organize a group of students to place their spring semester tuition in escrow, suspending their performance, their promise of paying spring semester tuition. After sending the university a letter in writing saying that we had reasonable grounds for insecurity about the university's ability to perform its promises in the spring semester. The right to suspend your performance when you have reasonable grounds for insecurity is a hidden gem of contract law. In summary, let's review the steps in the UCC that the court used to reach the final result. First, it determined under 26091 that McDonald's had reasonable grounds for insecurity to make a demand of adequate assurance of performance. Second, it determined that McDonald's is excused from 2609's requirement of a written demand. Third, it determined that AMF failed to provide assurance, adequate assurance, and that its behavior amounted to repudiation under 26094. Under 2610B, repudiation by the seller entitles the buyer to remedies. And finally, UCC Section 27111 shows that one of such remedies available to the buyer is cancellation of the contract. Among